years. That's average. That includes all the people that they're race raced through, and all the people who have formal defenses that get put up against them. So the deficiency judgment wanted to make sure everyone knows this is the danger in a foreclosure. They get the difference between what their judgment amount was for and what the value of the home was on the date of the sale. They will go back, ask for an order for a new judgment that says, if the house was worth $300 and they had a judgment for $450, they will get a judgment for $150, give or take. That will automatically become a lien against any other real property that you own. It will be valid for 20 years. They can take post-judgment proceedings to bring you in for depositions, ask you to produce all of your financial information, and there are some very, very detailed questions that they, and requests that they make. They can garnish your wages, meaning make your employer pay them a portion of your salary. They can go into your bank account and freeze your accounts and take the money there. They can sell your assets by sheriff's levy until the judgment is satisfied. This is the danger in a foreclosure. So our motto here is negotiate from strength. They can only hurt you once they get that sale date and once they have that deficiency judgment. Until then, it's just a fight. So what we do at our firm is we have different discovery waves that we use that are intended to address the different issues that come up in a foreclosure. Was the loan originated correctly? Does the plaintiff have standing? How was the securitization process done? Is that paperwork in order? Was the loan serviced properly? There are so many. Was there loss mitigation processes followed? Did they deal with you in good faith? There is a covenant of good faith and fair dealing written into every contract in Florida. These are all issues that we will use to say, yes, I know my client didn't pay, but there's a reason why you should work something out with us. Now, we talked a little bit, and I'm not going to get too detailed into this, but I want to make sure you guys understand. We talked about there was that process that all these loans were supposed to get pushed through in order to pop out a squeaky clean security that Wall Street could make billions of dollars of profits on. Well, this is the process. There's an originator, to a sponsor, to a depositor, to the trust. Each one of these arrows in between, the red arrows, are supposed to be what they call a true sale, meaning money is supposed to change hands. Documents are supposed to be assigned and endorsed. There's supposed to be transfer of documents. This process was the basis for these banks being able to say to these investors, don't worry, your loans are protected, because this allowed them to defend against any claims from a bankruptcy court, and it also allowed them to qualify for what's called a REMIC status, which is Real Estate Mortgage Investment Conduit status, which allows all the monthly payments to flow through to the trustee, or to the ultimate investor, without being taxed until it gets to the investor. So it was very important that they did this whole process, and there was supposed to be a sale of the loans from A to B to C to D. Problem was, they weren't doing it. Let me say that again. As the nation flew into this real estate boom, banks realized it was getting a little cumbersome to pay for someone to make sure all of these documents were properly executed, and that all these transactions behind the scenes were being done. And banks inherently are greedy and want to make more profits. They're not necessarily interested in helping people out, and they decided not to pay people to do that. Now, we've heard about the robo-signer scandal that was going on here, and the Florida Attorney General's office a few months ago issued a report from their Economic Crimes Division going into the unfair, deceptive, and unconscionable acts in foreclosure cases. You might have seen that on my website or on the email some of you might have received. That is 100 slides of, oh my God, what have these banks been doing? What they had was a company called LPS, and LPS was a mortgage servicing platform. It was a computer program that serviced about half of the mortgages in the United States. And LPS had a big lead on the market, in servicing these loans, because they would say, we'll pay your default servicing for you. You don't have to pay that, whatever banks we're dealing with. If you're our customer, we'll take care of it for you. And ultimately what they did in order to take care of it is when all these loans that were collateralized and securitized went bust, and they had to start unraveling everything. They had to go back to the courthouse and show how these documents were actually, that they had the right to foreclose. They went and found that they didn't have their documents. Why? Because those documents were not being created in the first place. This is not what I'm saying. This is what has become fact investigation by the 50 attorney generals in the United States. 60 Minutes did a report on this a few weeks ago, which is also on my website. It is true. Banks chose not to protect their interests. There is a case called U.S. Bank versus Ibanez out of the Supreme Court of Massachusetts, where the bank was not allowed to foreclose. And the Supreme Court, in the concurring opinion, the justice said he was shocked and amazed that banks were so inept and so careless about documenting their right to foreclose. It doesn't excuse the borrower for not paying, but it doesn't allow the banks to foreclose if they don't have their paperwork in order. So what LPS was doing was setting up companies like DocX, and what DocX did was hire people for $10 an hour to sign 350 bogus assignments of mortgage an hour. And they were doing this all over the country. These documents were being signed. That's where the term robo-signer came up. These people were signing documents. They didn't know what they were about, who they were. This is one of the assignments that the Florida Attorney General's office pointed out. If you notice, over the X's, it says that it would be delivered unto bogus assignee for intervening assignments. This was filed in a courthouse. It was signed by a woman named Linda Green as Vice President of America Home Mortgage Acceptance Company. Well, Linda Green, as you'll see, held many jobs. This is 2008 into 2009. These are all different companies that Linda Green signed as Vice President of MERS, of Bank of America, of America Home Mortgaging, of Deutsche Bank. All of these. And Linda Green, if you saw the CBS report, she was a $10 an hour employee of DocX. And many people who worked at DocX signed her name for her, even though there were notaries supposedly verifying it. It was all done, and it's shocking that more people don't know this information. But this is what we're seeing to be one of the biggest problems banks are going to have with foreclosures. Because what's happening is the banks are trying to foreclose, and they're just saying, let's just put this back in the trust. Who cares if our paperwork's in order? But there's REMIC trust investors who are saying, we don't want this to destroy the trust that we've created that gave us all these tax protections. And if you weren't doing the documents correctly, you're gonna be making our investment go from AAA to significantly worse. So it's a fight that's going on right now. And involved in that fight is a company called MERS, Mortgage Electronic Registration Services, our system. Over 50% of all mortgages are now what they call nominally owned by a company called MERS. Okay? MERS is a company that was created basically to track the servicing rights, who's acting as the servicer, and who is ultimately the beneficial owner of the mortgages, who are the investors. And what they did was, in every mortgage that was done by any MERS member, they would have a provision that says that MERS is the mortgagee in a nominee capacity for that lender. And what happened was, MERS would then record the mortgage once, and then any transactions afterwards were supposedly being monitored by MERS. And what did this allow them, Wall Street, to do? Well, all of those intervening transactions should have been recorded in the public records of every county where the property was there. That would have cost billions of dollars to do. MERS allowed these banks to avoid that. And who owns MERS? It's not just banks. I mean, there's several banks, but AIG is an insurance company. The Mortgage Bankers Association, Stewart Title, the title company, Freddie Mac, GMAC. These are all different entities that are huge players that all have an ownership interest, all decided we're just going to create this system of MERS that will take money out of the registry, out of the tax base or the budget for all of these counties where we are putting these more toxic mortgages in, and we'll keep track of it, is really what they were saying. But the truth is, MERS didn't do a very good job of that either. For one, all of the information that was put into MERS was put in by members who were not employees of MERS. MERS never verified any of the information that went in there. We're seeing MERS officers that are signing affidavits and assignments that don't have the proper seals or the proper corporate resolutions. They try to assign the note, which in Florida, in order to assign the note, you have to actually own the note. And MERS never takes ownership of any note, doesn't hold the note, doesn't have anything to do with the note. But they are trying to use this and get past what is basic Florida law in order to get the system approved by the courts. And there is a fight underhand. It started maybe 5 years ago. There was a case, MERS versus Sanchez, I believe it was, where Judge Gendon and Judge Gordon, two very fine judges here in Miami, held a hearing and found that MERS doesn't really have much interest in any of this stuff. But now we're back and we're seeing them coming back again, and we're still fighting the fight. But if you see MERS on your mortgage, it's something that means that there may be some issues we can work with. Now, there are the defenses to foreclosure: predatory lending, truth in lending, unclean hands, RESPA violations, Fair Debt Collection Practices Act violations. I will say this about all of them. None of them will get you a free house. Maybe unclean hands at best. What they will do is give you things to argue about, give you leverage in your negotiations, and ultimately would be an offset against whatever judgment the bank ultimately gets. But I think it's important to recognize, in the position that many of us are in, if the bank has their documents in order and you didn't pay, then you need to put whatever defenses you can, and make sure that they, are willing to let you out of this loan. Because if you don't put up your defenses, they're going to get their judgment against you, and they're going to try to use that and sell that off to someone else who will then come after you for however much longer, that judgment is enforceable. So, strategic resolutions. We've talked a lot about loan modifications, short sales, short payoffs, cash for keys, deed in lieu. Something we see a lot of is waiver of defenses for waiver of deficiencies. They'll give the bank the property back if the bank leaves us alone. Just some questions about the loan, loan modifications. I told you before, there's a lot of financial information you have to give to get it even considered for a loan modification or a short sale, actually. The truth is that in Florida, banks, no plaintiff is allowed to get to your financial information until they get a judgment. It's simply not discoverable. It's completely off limits until there's a judgment. The banks in these mortgage situations are the first ones I'm seeing who've ever been able to get people to willingly give it up. And if you give it up, you have to recognize that that is something they can use later to try to come after you if they ever do get a judgment. But that being said, if you want a modification, that's oftentimes a baseline starting point for them. They need the documents to do their analysis. We talked about if your modification gets denied and you're back to having to make